Hey, welcome back to Kelly's Take Two Pre-Licensing Review. Great to see you again. We are going to have some fun today, y'all. Because why? Because if it's not fun, I'm not doing it. Today, we're going to go ahead and review Unit 9, which in your textbook is called Basic Contract Law. Here's what I can tell you. There's nothing basic about it, but y'all, I'm going to break it down for you. I'm not an attorney. I only play one very poorly on TV, but I'm going to break it down for you as much as I can and put a lot of this legalese, a lot of this legal jargon into layman's terms so that you can what? Pass that test. Come on back. Give me a minute to get my props together. All right, team, pass that ding dang test the first time. You might be wondering, wow, what made Kelly decide to get so gussied up for today's lesson on basic contract law, which is a misnomer because there's nothing basic about it. Well, you'll just have to wait and see. It will soon make sense, as well some of my other props. Today's a prop heavy day, so get ready. It should be a lot of fun. All right, go ahead and get your note-taking materials out. We're going to dive in talking about the 4 essential elements of a valid contract. It's so important to go ahead and pin down what those 4 essential elements are right out of the gate. Why? Because if you're missing any of the 4, any of those, the status of that contract will be void. Go ahead and write that down, write it down, write it down. If you're missing any of the 4 essential elements, the contract status is void. Why is that a big deal? Because a contract that's void is one that is unenforceable. Where is it unenforceable, Kelly? In a court of law. All right, so let's start with the 4 elements, essential elements of a valid contract. I want you to write down 4 letters. We're going to do an acronym. I want you to write those letters down horizontally in capital letters, by the way. So write down the letter A, the letter C, then leave a little bit of space. Write the letter P, write the letter C. And then say those out loud to yourself. Does it sound familiar? What did you say to yourself? Did you say ACPC? Yes, you did. That sounds a lot like what? ACDC. Where's she going with this? Somewhere good, but you got to wait and see. Okay, I got to build a little suspense in here for a minute, y'all. This stuff that can be dry as an unsalted saltine cracker. Are you kidding me? All right, so let's just write down what those letters mean. The first letter stands for agreement. The legal term is assent, but you can, I'm breaking it down in regular people talk for you. The word is agreement. The parties have to agree to be in a contract together. The letter C stands for, you can use either the word competency or capacity, meaning the person has to be of sound mind and body. Sound mind and body, legal sound mind and body. Next, this P stands for purpose. The contract needs to be for a legal purpose. And the last C stands for consideration. The contract must include some type of consideration, something of value. That something of value does not need to be money necessarily. It could be a golf game. It could be a weekend at the beach. It could be, who knows, groceries, whatever, something of value. So those are your 4 essential elements of a valid contract. What did I say a minute ago? If you're missing one, the status is void. Why is that important? Because if the status is void, it's unenforceable in a court of law if you were to go see Judge Judy. Now back to our acronym ACPC. Remember I told you that sounded a little bit like what? ACDC. Hold on, wait for it. We're going to have a little fun. All right, well, ACDC. Y'all remember the song? I know you can't see me quite yet. I'm going to turn on the camera for dramatic effect in just a minute. But do you remember that song? TNT, I'm dynamite. TNT, I'm ready to fight. Okay, so we're going to change that up. We're going to use the tune, but we're going to use some different letters. What's it going to be like? It's going to go like this. Because it's ACPC, dynamite, ACPC, 4 elements of a valid contract, ready to go. ACPC, rock and roll. Fight, fight, fight. ACPC, y'all. You're not going to forget it. Why? You got all 4 elements. We're what? We're ready to rock. I'm sure that was a little bit of a shocker. Okay, if you're still with me, you're a brave soul. You're a brave soul today. All right, so we have established that there are 4 elements to a valid contract. If you're missing any one of them, the contract status is void. That's important. Why? Because if you go to the court of law, it will be unenforceable in a court of law. Now, you could have a valid contract, or one that is purported to be a valid contract, one where you say, okay, we've got all the elements, but something has happened to call something into question, shall we say. So anytime if there's a future event or circumstance that might call into question this contract and its validity, then we may be moving into what's called avoidable territory. You could have a valid contract with all the elements, but something has happened in the future to call it into question or to disaffirm it, shall we say. So for instance, get ready, you're going to want to write this down. For instance, when you go to, let's say you have a disagreement over a purported contract, and you go in there to see Judge Judy. Judge Judy is going to say what? First, she's going to say, hey, zip it. I want to talk to y'all. Show me your supposed contract. So she's going to snatch that from the bailiff or whatnot. She's going to look it over. Then she's going to check. She's going to ask some questions. She wants to see, okay, yes, y'all signed this, which would seemingly denote agreement. That's the first letter in ACPC. That would seem to establish agreement, but do we truly have agreement? So she's going to double check. She's going to double check by asking 4 questions. You're going to write this down, write this down. She's going to ask 4 questions to establish reality of consent. She's going to ask, do we have any undue influence? Number 1. Do we, number 2, have any duress? She's going to ask number 3, do we have any mistake of fact? That's called a misrepresentation. Or number 4, do we have any straight up fraud? In the absence, if the answer to all 4 questions is no, we don't have any of that, then she's going to say, okay, check, we have agreement. However, if the answer to one of those 4 questions is yes, one party was under duress, or yes, one party was experiencing undue influence, or yes, there was a mistake of fact that would harm one party, or yes, someone straight up lied, there was fraud and that harmed one party. The answer to any of those 4 questions is yes. That's going to put us into the voidable category. So the person who is harmed, the person who is feeling duress, the person who is under undue influence, the contract will be voidable by that individual, by that party. Now, if it's voidable, the party who's injured, the party who's harmed is going to be at a crossroads, just like Robert Johnson, except not quite as, never mind. Okay, so the person's going to be at a crossroads. When the contract is voidable, that party can either choose to move forward with the contract and see it to fulfillment, or that party may choose to go the other direction, back out of the contract, rendering it void and thus unenforceable. So they have a choice. The injured party always gets to choose an avoidable situation, either to move forward or to void the contract, to back out, to void it without harm, without penalty. There are many reasons that could cause the status to be voidable, but there's only one way to have a straight up void contract, and that's if you're missing what? one of the 4 essential elements. The essential elements spell what? ACPC, we're ready to rock. Agreement, capacity, purpose, consideration. All 4 of them valid. Missing one, void. Okay, let's continue on. You may have a void contract, and we've established that a void contract is unenforceable when you go to see the judge, but you could have a contract that is valid and still unenforceable. What do you mean, Kelly? Let's use the example of a real estate contract that's created on a handshake. I promise to do this on a handshake. You promise to do that on the handshake. We've made contractual promises to each other regarding perhaps the sale of a property. But if we were to go to court and go talk to the judge about enforcing this handshake sales contract, we'd be laughed out of the courtroom. What's up with that? Well, there's a little bit of common law called the Statute of Frauds. And the Statute of Fraud states that real estate contracts and a few others, I'll tell you about those in a minute, real estate contracts must be in writing in order to be enforceable in a court of law. Now, one of my former students made us a little thing to remember the Statute of Frauds, and it's called the Statute of Frogs. Listen, the goofier it is, the more you're going to remember it. It's an actual thing. It's called salience in learning. I know, I'm just saying. Okay, so the Statute of Frogs, there it is. She actually printed out the statute and shrunk it. Look at that. Is that the cutest thing ever? Okay, so what does it say? Write this down. It's very, very testable. Statute of Fraud states that certain real estate related contracts and documents must be in writing in order to what? Be enforceable in a court of law. What are the other real estate documents? Here we go. There are 6 in total, and one of them would be the sales contract. We've already established that. So what are the other 5? Ready? Here we go. Deeds. Next, mortgages. Next, option contracts. Next, easements. Next, leases that are for more, and put more in capital letters and highlight it, more than 3 years. It's typically going to be a commercial lease, but leases that are more than 3 years. And then, of course, I already mentioned real estate sales contracts. All of those must be in writing in order to be enforceable in a court of law. All right, very good. Now let's talk about, we went into a little bit of detail regarding the A in ACPC, agreement. And we talked about this notion of reality of consent, that the judge is going to look for, okay, do we really have agreement? Y'all signed this thing, but do we really have agreement? She's going to ask you those 4 questions. And if the answer to those 4 questions are all no, then she will or he will establish, yep, we've met agreement, we've met reality of consent. That's what that means. Now let's talk about capacity. It is very difficult to prove that somebody is legally incapacitated or lacking competency. So it's more likely that somebody could be temporarily incapacitated. If somebody is temporarily incapacitated, the status of that contract, even though they signed it, right? So they signed it, it looks like it's valid, but we've gotten new information. We have found out that one of the parties that signed this was temporarily incapacitated. What could cause somebody to be temporarily incapacitated? The first one always comes up. Someone's like, Dion Rook. They're intoxicated at the time they sign this thing, or they're on drugs or some such thing. Okay, those are common. But listen, I just picked my husband up the other day from a medical procedure where he was having to come out of anesthesia, and he was given a warning in his paperwork that said, do not sign any contracts, documents. You're coming out of anesthesia. You are temporarily incapacitated from making those types of decisions. It could also be someone could be temporarily incapacitated due to a mental health episode. Maybe they're in mania. Maybe they're experiencing PTSD, those sorts of things. Now, will they have to go to court to prove it? Yes, they will. But if it's proven, then that person who has been deemed temporarily incapacitated at the time they sign this purported contract, again, they're going to be at the crossroads, just like Robert Johnson, and they're going to decide who's Robert Johnson. You just have to Google it. Okay, just Google it. All right, they've got a choice to make at the crossroads. They can either move forward and say, yeah, I'm still good. Let's just keep rocking and rolling with this contract. Or they could say, nah, I don't know what I was thinking. And they can back out, void that contract, rendering it unenforceable in a court of law. Now, an interesting one that really gets people twisted up like a pretzel in my class is dealing with minors. You see, people, let's call them people under the age of 18 are, in the eyes of the law, seen to be temporarily incapacitated until they reach the age of consent, which is what? 18. So if you enter into a contract for anything, a computer, a car, a phone, a scooter, skateboard, who knows what, you enter into a contract with a minor under the age of 18, that minor could come back and what? Void that contract out. So contracts with a minor are voidable, and they're voidable for a few years after that minor turns 18 due to something called the statute of limitations. The statute of limitations typically is anywhere from 3 to 4 years, but as my attorney friends like to say, really, that time frame depends. And actually, you'll have to go see a judge in order to determine when the clock started ticking on that statute of limitations time frame. So anyway, let's get a little deeper than we need to go. All right, so we've established that the judge is going to check on when you go in front of the judge with some type of a contract dispute. The judge is going to make sure we have true agreement using those 4 questions to establish reality of consent. Then the judge is going to see, do we have any evidence of temporary incapacitation? All right, so nope, we don't have any temporary incapacitation. So next, the judge is going to say, okay, well, is this purported contract for a legal purpose? For a legal purpose. Here it comes, y'all. Just a minute. Wait for it. All right, so for a legal purpose, what does that mean? Well, what would not be a legal purpose? Can you think of one? Is it starting to click why I'm wearing this outfit? I don't know. Let's check it out. Carol Baskin killed her husband, whacked him. Rare. It didn't happen. Rare. Okay, did y'all watch The Tiger King? Come on. Like everybody during COVID, during the pandemic, everyone's watching The Tiger King. Well, Joe Exotic put a hit out on Carol Baskin. That's on just a best Carol Baskin, okay? He put a hit out on her. Yes, he did. He is serving a big old sentence in jail, 20-something year sentence for putting a hit out on her. All right, now, he made a deal with one of his employees. He said to this employee, according to the documentary that maybe I watched more than one time, maybe I didn't, okay, that he would pay this employee $5,000 if he would go knock off Carol Baskin. Well, guess what? The guy in the employee during the documentary said, well, he only gave me $3,000. I wasn't really going to go knock her off, but I was going to take the money. Can you imagine if this gentleman, shall we say, went into a court of law to say, hey, Joe Exotic owes me another $2,000? No. And in fact, she's going to call bailiff, cuff this guy. We got a murder for hire plot. So a murder for hire plot, putting a hit on someone, that's a contract, but it's for an illegal purpose. Therefore, it's what? Void, unenforceable in a court of law. I have a couple other examples as well. As y'all know, currently, various states have various laws about various herbal substances, shall we say. Is she talking about the weed? Is she talking about, you want to irritate your children, you just start calling that lots of funny things. They call it funny things too. They call it gas. That's what that is. I like to make them mad and call it things like, Mary Jane, I love you just the same. Or worse, they really get mad if you call it reefer. They just go crazy. They lose their minds. And it's really funny. Anyway, some states that's a legal situation. In North Carolina currently, it is not legal. So if you create a contract here in North Carolina with a dealer, the young people call them plugs. Just saying, okay. If you create a contract with your dealer for some marijuana and they don't bring you the right amount, you feel like you got ripped off, good luck going to court. Okay, why? Because that contract was for an illegal purpose. It will not be enforced. It's unenforceable in a court of law. Plus, again, the judge is going to say, bailiff, cuff them. We've got a dealer thing going on over here. Okay, so you want to avoid that at all costs. All right, let's move along. So we're going to move on to consideration. Consideration is anything of value. Contracts must have some type of consideration. It could be monetary. It does not have to be monetary. It could be anything of value. Now, in a real estate contract, which is what we talk about in Unit 10, the consideration is actually the promise to buy for a certain amount of money and the promise to sell for a certain amount of money. So it's the promise to buy for $200,000, the promise to sell for $200,000. So it's the sale price is the consideration. Many people mistakenly think that earnest money is the consideration in a real estate sales contract, and that, my friends, is incorrect. Note to self. You don't even need earnest money to create a valid real estate contract. Earnest money is really just kind of this custom out there. You might want to think of it as good faith money, where the buyer is going to write a check to a trust account, essentially, that says what it says to the seller is, I'm so serious about buying your house that I'm willing to put up X amount of money in earnest money to be held until I complete the contract, until I fulfill the terms of the contract. And the terms of the contract means I'm going to buy your house. Let me add one more little side note regarding a contract dispute and going in front of the judge. If you show up in court in front of the judge and the judge establishes, yes, we definitely have a valid contract, the judge has checked the ACPC to see if indeed, do we have anything to disaffirm the validity of this contract? And he or she has established, or they have established, no, we've got a valid contract right here, we're good to go. Well, you know what happens. You've seen the TV show with Judge Judy. What happens? Each party starts flapping the lips. They start yammering away and saying, well, we signed that, but he really said blah, blah, blah. And she really said blah, blah, blah. What is Judge Judy going to say? She's going to say, pipe down. She's going to say, take a seat. And then she's going to say, you know what? In my courtroom, we don't go for this speech business. Oh, no, because in my courtroom, whatever is in this written document stands. So if we've established we have true agreement, whatever y'all have agreed to in this written document, you signed it, it stands. I am not, the judge is going to say, so I'm the judge, just play one badly on TV. The judge is going to say, I am not going to listen to all this yammering back and forth. I am not going to allow your verbal speech, whatever you said, he said, she said, blah, blah, blah. None of that is going to override what is written in this document right here. And that, my friends, is called, wait for it, drum roll, please. That, my friends, is called the parole evidence rule. Parole does not mean like you're on parole, got out of jail, now you're on parole. That would have an E on the end. Parole is P-A-R-O-L, and that is Latin for speech. So the rule is the judge typically will not allow, like almost always, will not allow verbal evidence, oral evidence to override what's in a written document. Because, now watch me tie some things together. Ooh, Kelly, okay, let's tie some things together. Because the statute of fraud says, that the best evidence of what the parties have agreed to is written.